Thanks very much for this kind introduction, and thank you very much both to Her Excellency Judge Julia Sebutinde, my former boss here at the ICJ, and to the Institute for Cultural Diplomacy for this kind of invitation. It's of course a very special privilege and pleasure for me to be here in this beautiful building that used to be my second home for 4 years. I've only been away for a little bit more than half a year now. And I miss my team, which was like a family, and I miss this building. So it's quite emotional to be back here, especially since I've sort of moved from the state responsibility mechanism that the ICJ is to the actual international criminal justice mechanisms, having a chance to see these two very different sides and approaches to dealing with questions that include issues of human rights. But I have decided today to focus my presentation on the International Court of Justice's role in the protection and promotion of human rights. There are several reasons for that. One of them is that this agenda features a lot of speakers that are speaking from the criminal justice experience and the experience of human rights mechanisms and institutions, whereas my experience, of course, might contribute to show how the International Court of Justice, which in principle is not a human rights court, also plays an increasingly important role in this field. I think this is also particularly important to start looking at the complete picture of the mechanisms of international justice that contribute in this field in these times that keep reminding us, as the beginning of this year has, that we, in terms of protection of human security and human rights, still aren't where we aspire to be. This year, as most others, has started with violent, brutal attacks against civilians in Paris, Nigeria, elsewhere in the world, alongside continued armed conflicts, human rights abuses everywhere. But we also should be reminded that in these same terms of human security and human rights, we also are no longer where we used to be. We tend to be pessimistic, but we forget that the human rights law, substantively and procedurally, has evolved to the level that was unimaginable to the drafters of the UN Charter, and that the institutions for protection of human rights have evolved globally and are extremely, extremely busy and intense. Within just a span of 1 week, this last week, the ICTY Appeals Chamber has convicted 5 accused for committing genocide in Srebrenica 20 years ago. And just 2 days ago, this very International Court of Justice has delivered its second judgment concerning allegations of genocide within less than a decade. So, International Court of Justice, even though not a human rights court, has a role to play in this field. Its role is limited for at least 2 jurisdictional reasons. First of all, as you know, the individuals cannot be parties before the court. And secondly, not that many human rights treaties include a jurisdictional clause providing for the court's jurisdiction. And those treaties that have this kind of clause very often include reservations or preconditions for the jurisdiction of the court, such as the requirement that the parties have to first try to settle their disputes concerning human rights through some other mechanism or negotiation. Nevertheless, of course, the International Court of Justice is one of the few courts with a general subject matter jurisdiction, and it therefore has the competence to address any question of international law, including human rights law. And we also should not forget that the ICJ is the principal judicial organ of the United Nations, and as such, has to fulfill its function in line with the principles of the organizations, including the protection and promotion of human rights. And one might be surprised to learn that indeed human rights have featured in the court's jurisprudence from the very beginning of its work. In 1949, when the court decided its first case between the United Kingdom and Albania, the Corfu Channel case, human rights law was still in a very embryonic phase. But the court still found it important to underscore the relevance of what it called a general and well-recognized principle of elementary considerations of humanity. Now, over the years, the court increasingly made pronouncements on various aspects of human rights. And today, its decisions in both contentious and advisory proceedings routinely address a wide range of human rights issues. Along the court's own pronouncements, of course, we have individual judges, some of whom have a strong background in human rights, who frequently append their individual opinions, separate dissenting opinions to the court's judgments, of course, additionally contributing to the human rights discourse on both academic and practical levels. Now, the court itself, in its jurisprudence, has importantly contributed to the development of the substantive international human rights law and international humanitarian law. It made several pronouncements on the normative status of human rights norms, as well as on the scope of application of international human rights instruments. Now, having looked at today's agenda, I assume that His Excellency Judge Yusuf will soon discuss these issues on the development of human rights law by the court in much more length and with much higher authority than me. But I would just like to observe, to point out, of course, that the court has, among other developments, confirmed the customary law status of certain fundamental human rights principles, such as the prohibition of genocide or the prohibition of inhuman or degrading treatment. The court has also recognized, importantly, that these norms and other norms of basic human rights engender so-called obligations erga omnes, which are the concern of all states and may be invoked within the framework of state responsibility by any state. The court has acknowledged also the concept of jus cogens norms in positive international law and had placed into that category, again, the prohibition of genocide, as well as all violations amounting to crimes against humanity and war crimes. Now, in addition, the court's recent jurisprudence has importantly confirmed that human rights treaties apply also extraterritorially and that they continue to apply in the context of armed conflict and occupation. This, of course, reflects that the court handles its cases with full consciousness of the evolving contemporary security environment and human rights. In terms of enforcement, the court has occasionally even had occasion to directly enforce human rights and their protection. It can do so through finding of a violation by a state of its human rights obligations and, of course, determining the appropriate remedies. One of the most important ways in which the court helps enforcing human rights directly, however, would be the indication of binding provisional measures. The court plays a big role in this regard, and there have been a number of cases where the court has indicated binding provisional measures intended for immediate protection of human rights, particularly in situations of armed conflict. And it has, in this context, also confirmed that every state is legally bound to carry out and impose these provisional measures. It has done so not only in cases where human rights were directly the subject matter of the very dispute at hand, such as, for example, the recent genocide case and other cases involving human rights directly, but it has also done so on its own accord, proprio motu, in cases where human rights were not directly the subject matter of the dispute, such as most recently in a territorial dispute between Cambodia and Thailand. Now, another and final important pathway through which the International Court of Justice contributes to promotion and protection of human rights is perhaps less obvious. Through this pathway, the court is steadily, I would say, affirming its place within the global framework of human rights mechanisms. As I've already indicated, the court's jurisprudence increasingly refers to both legal and factual findings of regional human rights courts. In its most recent judgment on Tuesday in the genocide case, the court has very much relied on the jurisprudence of the European Court of Human Rights, Inter-American Court of Human Rights, African Court of Human and People's Rights, and of course on the jurisprudence of international criminal tribunals, the ICC, ICTY, ICTR. More than that, the court also quite frequently and increasingly so refers to findings of other human rights treaty monitoring mechanisms, such as the Human Rights Committee, and it has also occasionally relied on the findings of the special rapporteurs of the UN Commission on Human Rights. In addition, the court has also increasingly read into and borrowed from the findings of non-governmental human rights organizations such as Amnesty International and Human Rights Watch. In turn, these bodies have frequently utilized and benefited from the court's jurisprudence and have quoted the court's jurisprudence and pronouncements in their own decisions or judgments. Now, despite the views that have been frequently voiced in the recent years that this trend might involve a risk of fragmentation of international human rights law, and thus the fragmentation and less efficiency in the protection of human rights, when one looks at the court's jurisprudence and at the jurisprudence or decisions of these other human rights protection mechanisms, one sees that there is in fact more unity, more uniformity of views rather than the divergence of views. And that confirms that, in fact, international human rights law is not a series of fragmented regimes, as is sometimes said, but it is an increasingly united system of rules and mechanisms for global protection of human rights. And in this very context, it is where the ICJ, of course, carries a special weight as the principal judicial organ of the United Nations, but also due to the very high authority and legitimacy of its decisions. Its jurisprudence helps consolidating the international protection of human rights by contributing not only to the development of the substantive principles of international human rights and humanitarian law, but of course also to affirming the legitimacy of other human rights protection bodies and international courts and tribunals. Thus, the Court does contribute to the greater efficiency and strength of the global structural framework for protection of human rights. I will stop at this point, and I would like to thank you very much for your attention. Thanks for having me.